Hello, I'm Jennifer. Welcome to another episode of Case Brief, brought to you by the Missouri Sheriff's Association. Before we get started, I want to remind everyone that this information is for training purposes only and in no way is to be considered legal advice. Today, we focus on an Eighth Circuit Court case related to a jail's postcard-only policy. Our goal is to provide a clear understanding of how such cases unfold. Remember, this content is educational and not legal advice. So, let's dive into the details. HRDC publishes and distributes books and magazines designed to inform prisoners about their legal rights and news stories about the criminal justice system. It distributes these publications to subscribers and sends unsolicited mailings to prisoners with an order form in hopes of recruiting new subscribers. In 2016 and 2017, HRDC sent numerous books, magazines, and other mailings to inmates at the jail. But the jail had adopted a policy limiting all non-legal mail to inmates to postcards, so HRDC's mailings were rejected. HRDC then filed this lawsuit against Baxter County, asserting the jail's postcard-only policy violated its free speech and due process rights under the First and 14th Amendments of the United States Constitution. The district court awarded partial summary judgment to HRDC on the due process claim related to some mailings, finding a technical violation of HRDC's right to notice of the reason its publications were rejected, but held the postcard-only policy did not violate HRDC's free speech rights following a bench trial. At that time, the Eighth Circuit Court vacated and remanded the decision back to the district court as to the First Amendment ruling, concluding additional fact-finding was necessary on whether HRDC had any available alternative means to exercise its First Amendment rights. Upon remand, the district court held an evidentiary hearing and ultimately found the jail's policies created a de facto ban on any HRDC publication, and that permitting HRDC to directly send its publications to inmates at the jail would have had a de minimis impact on the jail's operations. Based on these findings, the district court concluded the jail's policy was not reasonably related to legitimate penological objectives and therefore violated HRDC's rights as applied to HRDC's publications. It awarded a permanent injunction of the postcard-only policy as applied to publications directly mailed from a publisher and attorney fees and costs. Baxter County appealed, arguing the district court erred in its determination of the First Amendment claim and the award of attorney fees and costs. To determine whether a jail policy violates the First Amendment rights of an entity seeking to communicate with inmates, the Eighth Circuit Court asked whether the challenged policy is reasonably related to legitimate penological interests. And this inquiry turns on four considerations, commonly referred to as the Turner factors. 1. Whether the policy has a valid rational connection to a legitimate governmental interest. 2. Whether alternative means are open to those desiring to communicate with inmates to exercise the asserted right. 3. What impact an accommodation of the right would have on guards and inmates and prison resources. And 4. Whether there are ready alternatives to the policy. Without a rational connection to a legitimate governmental interest, a policy fails the Turner test, irrespective of whether the other factors tilt in its favor. Baxter County asserts the postcard-only policy promotes security and efficiency at the jail by limiting contraband and the time it takes to screen mail. These interests in reducing contraband and promoting institutional efficiency are legitimate. The Eighth Circuit Court has twice affirmed similar postcard-only policies as rationally related to these interests. C. Simpson v. County of Cape Girardeau. The Eighth Circuit Court agreed the first factor of Turner favors the jail. However, the court's analysis does not stop there. Next, the court asked whether HRDC had available alternative means to communicate with inmates, or if instead the policy acted as a de facto permanent ban on communications. In concluding the jail had a de facto ban on HRDC's ability to communicate its publications to inmates, The district court found that, except for soft-bound, hand-delivered Bibles and court rules contained in the jail's milk crate, which served as the law library, the county's policies prohibited inmate access to all publications. Inmates at the jail could not access the internet or other electronic reading options like a kiosk or tablet. During the relevant time period, the only possible means of communicating with inmates was through postcards or speaking with an inmate via phone or in-person visitation. In light of the repeated testimony that publications could not be sent to the jail, the Eighth Circuit Court did not reverse the district court's factual conclusion that the jail policy was a de facto ban on HRDC's ability to communicate its publications to inmates. The second factor of Turner favors HRDC. Regarding the third and fourth factors, the district court found only a de minimis impact on the jail's resources and its interests if it adopted an alternative policy permitting publishers like HRDC to send its publications to inmates at the jail while continuing to limit to postcards non-legal mail from other individuals. The district court noted that no publisher besides HRDC had ever sought to send publications to the jail, so there was no reasonable basis to believe that permitting publisher mail would have more than a slight impact on mail screening. Inspecting these few publications requires no more than a minute or two, and jail staff explained their review of these materials amounted to shaking them around and flipping some pages. One jail employee even explained he did not screen a local newspaper prior to distributing it to inmates, including those in segregation due to disciplinary issues, which the district court viewed as evidence that the jail's concern about contraband from publishers was minimal. With the facts showing that HRDC was likely to be the only entity to send publications to the jail, and an absence of any non-speculative basis to show that its mailings presented a security threat, the district court did not err in finding an alternative policy with a de minimis cost to the jail. Thus, the third and fourth factors also weigh in favor of HRDC. In sum, the Eighth Circuit Court found the jail imposed a de facto ban on publications, even though it could provide an alternative accommodation with only a de minimis cost to its operations and interests. Having analyzed each factor, the court's task was not balancing the factors, but rather determining whether the jail showed more than simply a logical relation between its interests and the policy. That is, whether the jail showed a reasonable relation based on the court's conclusions on each factor, with an onerous burden on the free speech right and little burden on the jail to provide the requested accommodation. The district court did not err in concluding the jail's policy is not reasonably related to its legitimate objectives. According to the Eighth Circuit Court, in light of the restrictiveness of the jail's policy, barring all publications in contrast to the limited impact accommodating publishers would have, we conclude the postcard-only policy was not reasonably related to its penological goals and was instead an exaggerated response constituting a blanket prohibition on HRDC's publications. This does not mean that the jail must accept any HRDC publication mailed to it, only that it cannot reject them because they are not postcards. But there is a significant difference between banning certain issues or versions of publications and a blanket ban on publications in the jail. The Eighth Circuit Court concluded the blanket ban on the publisher's materials violated the publisher's First Amendment rights in light of the district court's finding that the jail failed to show more than a de minimis cost if such publications were permitted at the facility. Before we wrap up, I want to stress that this decision highlights several critical considerations regarding the denial of publications from publishers in correctional settings. Those considerations are: 1. Overbreadth of policies. Blanket prohibitions that do not consider the content or potential security risks of specific publications are likely to be deemed unconstitutional. 2. Lack of alternative means. When inmates and publishers are deprived of all alternative means of communication, courts are more inclined to find such policies unreasonable. 3. Minimal impact on resources. If accommodating the distribution of publications imposes only a minimal burden on resources, Blanket bans are less likely to be justified. And 4. Availability of less restrictive alternatives. Jails are encouraged to consider less restrictive measures, such as individualized content review, to address security concerns without broadly infringing on First Amendment rights. This case underscores the necessity for jails and correctional institutions to carefully tailor their mail policies, ensuring they are directly connected to legitimate security concerns and do not unnecessarily impede the constitutional rights of inmates and external correspondents. Thank you for joining us in this episode of Case Brief. We hope this analysis provided valuable insights into the aspects of jails restricting outside publications. Stay tuned for more episodes brought to you by the Missouri Sheriff's Association. If you enjoyed this content, please like and subscribe. We look forward to bringing you more informative episodes in the future.